Thank you for attending this session with us. We are going to be talking about POPIA and PAIA compliance, or is your practice compliant? So I am going to introduce to you Joubert Le Roux, who is the Managing Director of the CFO Group. It's a long resume, and I'm not going to bore you with all the details, but I'm going to say this to you. Joubert is a distinguished chartered accountant with over 15 years of extensive international experience. He is recognized for his proactive and result-driven approach to financial management. This is the man that you want to have involved in your practice to make it run smoothly, to make sure that it's compliant. So I am going to hand over to Joubert. Joubert, thank you so much for being here today. And the stage is all yours. Thank you so much.
Joey, thank you very much for the opportunity. Good afternoon, everyone, and welcome to our session. So today we'll be discussing two important and critical legislations in South Africa: Protection of Personal Information Act, POPIA, and another side, promotion of action. Whoops, sorry for that. This don't go back. Okay. Well. And one is the Promotion of Access into Information Act. One would think that by now businesses and organizations would understand that protecting personal information is important for their survival and to share that information they have on people with their clients back and forth. And yet, here we are. We have two laws that we have to comply with. And failure to comply with these laws lead to severe penalties and even imprisonments. So, and make no mistake, these laws are highly technical because it's based on a GDPR Act from Europe. So let's delve into them. So the purpose of our presentation today is threefold: to guide you through the most important aspects of POPIA and PAIA, and also to give you practical tips on these legislations, and then to give you opportunities in these legislation. Because like I rightly said, these laws have been written very well, so it actually will help your business to survive in the end of the day. Because a breach can cause your practice to be ruined if you don't do that. So here we have, on the one hand, we have a Promotion of Access to Information Act, it's called PAIA. That became effective 1 January 2022. And the purpose of this act is to promote the right of access to information and also to foster a culture of transparency and accountability. And on the other hand, you have Protection of Personal Information Act, POPIA. This became effective 1 July 2021. The purpose of this act is to protect personal information and to strike a balance between the right of privacy and the need for free flow of information. And make no mistake, POPIA and PAIA is a daunting task of additional administration burden on your practice. So what is the connection to healthcare? And forgive me if I do repeat something, but at the end of the day, you'll get it. On the one hand, you have PAIA. This ensures access to medical information when legally appropriate. Now, I'm going to climb on here. Please note today, when legally appropriate. So, yes, you have a law that requires you to give out information, but you need to use your judgment. You are professional people. You do know well there, but you can't just give out information in certain conditions. You've been well trained to adhere to these rules and laws. And on the other hand, you have POPIA that protects personal information from unauthorized access. So medical practices need to balance their access right with data privacy obligations. And you see, here's the thing. Compliance is more than a legal obligation. It protects trust and upholds integrity of your practice. Failure to comply can result in substantial fines and reputational damages. I hope I have your attention now. And once you get to the penalties and you do not get it, well, then I rest my case. And I haven't done my job. So, at the end of the day, to best understand this, the general principle of both these legislation is this: personal information always belongs to the data subject, to your patient. You are merely, I'm sorry to say, You are merely the custodian of that information with a duty to store that personal information securely and to ensure it is kept up to date and to be able to provide the data to the subject data on request by. So, just a disclaimer from my side. While this presentation was done with great care, and it took a lot of time to do it, is not to be used as a substitute for formal legal advice. And the reason for this is POPIA is a principle-based legislation which allows for many variables, something that I cannot cover in this short section. And what can influence what's the best practice for your business. So please bear that in mind during this presentation, please. So yes, let's start off with PAIA. So what is the purpose of PAIA? Like I said, to promote right of access to information and to foster a culture of transparency, accountability and openness by granting individuals access to information held by public and private bodies. So what is the key requirements for PAIA, for medical practices for the PAIA legislation? Yes, you need to be compliant. You need to be compliant as a private body. And all information needs to be handled confidential and lawful access. You need to appoint the information officer. Now, information officer is central to the success of this act. On the one hand, it's a legal requirement, and on the other hand, it protects your business and your practice. And the last one is a PAIA manual. Now, the good news for you today is on the information regulatory site, there's a free manual, a free guide available on how to use the PAIA Act. It's in very simplistic English, easy to understand. So, and also there's an example of a PAIA manual from the regulator, and that will help you to draft your own manual. It's really not the rocket science, but it's important that you have it. So how do we access information? Yes, this is a whole diagram there on the right-hand side. So yes, you can see that it looks rather complicated. But the process is actually simple. If you use the guide from the regulator, the one that's free of charge, it will guide you nicely through the process. The whole process starts if you get a request for information from your data subject or patient, asking to have access to his information. So typically, somebody will be your patient for years. They come to you, they say, please give me my medical information. I want to go to another doctor. In that process, you need to apply for that information, and then the information officer needs to decide to give that information or not. And they have 30 days to do it, which can be extended if needed. And then the whole process ends there. And it's actually rather simple. But then you can have grounds for refusal of information. So you can have a grounds for refusal of medical practices for information. We have patient confidentiality and doctor privilege, patient privilege, violation of third-party privacy rights, and then also request that compromise and practice legal and ethical obligations. And the next one, last one, is privileged legal communication of classified medical data. So now you can also, what remedies does a patient have if you refuse to give them information? So here we go. Patients can appeal refusals to the information regulator. Legal action may be taken in cases if they want to pursue them. And then information regulator enforces compliance and provide guidance. So again, the information officer is a key person in this whole process. He's the one who gets the application and decide to give that information out. If you treat that as the same as money, so like a CFO or chartered accountant for your financials for your company, before any money go out, somebody needs to take responsibility for it and to issue the information out. Right. So in short, the key summary and key takeaways. PAIA insured patients can request access to medical records under lawful conditions. And medical practice must comply with strict privacy and confidential requirements. The information officers play a critical role in managing compliance. Proper record adherence to both POPIA and PAIA are essential for legal and ethical practices. Right, now we move on to POPIA. Now everybody has heard about POPIA, I'm sure. So just again in short, the purpose of POPIA is to promote transparency and accountability in how personal information is collected, processed, stored, and shared. POPIA is applicable to all organizations, public and private companies, for manual records and electronic documents. And I'm just going to delve now a bit into the POPIA Act. And if I say a bit, it's just going to touch on the surface of it, but it's important for you to understand this. So the categories of personal information in the POPIA Act is as follows. Number one, you have general personal information. Then you have a category special personal information. Then you have another one, children personal information. Now this one, please note, information related to minors under 18 years old is strictly protected. So yes, we have general information, special personal information, I can explain. And now I'm just going to look at the first two of these. Take note of number 3. So if you deal with children, you need to be extremely careful with dealing with that information. And then you have personal information of juristic persons. This is like companies, trusts, etc. And then last one is biometric and digital data. It's typically like your fingerprints, retinal scans, and voice recognitions and that. So here's an example for you of general personal information. So it's typically your name, surname, initials, physical address, language, etc. Now, you as a practice owner or as an information officer need to decide, do you need all this information? You do not need all this information. I can uncategorically tell you that today. And this is a thing of POPIA. I force you to think, what information do I really need to have? And as we move on, you'll see why I'm saying that. So here's special personal information. Now, special personal information is sensitive information that requires additional protection under POPIA. You remember number 3 we talked about just now, children requiring special protection. This is additional protection. It's like a level 2. So what kind of information is here? Which is like requiring special protection, additional protection. It's health information, religious belief, etc. And why is this important? Why is it important that we need to have a special category? So let me ask you today, is there anyone here today in public who would like to discuss their criminal behavior? Anyone? Okay, thank you. I'm glad of it. So, and I'm going to stop there. Just one more question. Anyone that then would like to discuss their health information with us? No one. Okay, thank you. So, if you do not want to share it out in public, so much more your patients and your clients would not like you to share that information. So, now for the interesting part. Regulations and POPIA that may assist you. POPIA force you to be able to justify why you practice collect and process personal information. POPIA, this is actually an opportunity to access the data you gather from both patients and staff, but determine if it's truly necessary. And be mindful how you collect information. For example, do you really need, remember number 1, do you really need to know a patient's marital status, race, or profession? Do you really need to know that? If it's important for you, maybe profession, I don't know, but you need to be able to justify why you keep that information. And need to consider how information is collected. For example, if somebody is sitting in a reception room, please do not call out the guy and say, hey, Joubert, I do not like what you said here, and etc., because that is a direct transgression of a POPIA Act, and it can land you in big trouble. Now, another thing that POPIA can help you with to make data security privacy a habit. Now, please, this is nothing new. You know about this since your studies and since you've been involved in a business on the medical industry. Here's HPCA booklets 4 and 5. This is about consent of patients to collect information and to process that information. POPIA PAIA merely reinforce the need to do this. So actually POPIA override a number of legislation. So in my field on the financial side, the Financial Intelligence Act need to be rewritten, SARS and VAT, and it affects a number of places because this now is a new regulation on all laws. At this stage, it actually overrides some of these regulations. So, and the last one is eliminate unnecessary personal information. POPIA requires only to retain personal information you really need. So, for example, if you had an interview for a job application, you do not, and once you finish legally, and you do no longer need the documents, you need to shred and need to destroy that documents as good as good. Please do not leave CVs of people lying in email boxes, because if you have a breach, you can be held accountable for that, which is uncalled for and unnecessary. It's just called house cleaning, straight and simple. So keep your house clean. You see, that's actually the advantage of POPIA and PAIA. And so similarly, if you need any documents of health-related information, when you destroy it, please make sure that you shred the information. Do not just throw it away. Because I don't know if you're aware, but health information is very valuable on the black market. People will pay more money for that than banking information. So you need to be careful. So then moving on to tips. Whenever you handle personal information, please ask yourself, have I collected only the information that I need? Is information securely stored within my practice? Have a patient given consent for their data? And if no consent is now the last point, I want to share some time, but spend some bit of time. If no consent, is sharing of allowed in the patient's best interest? Now, on this one, I'm not going to tell you anything because I can't. I'm not in a position to tell you how to do it. So you need to use your professional judgment. So from my point of view, I would recommend that if you decide to share information and you do not have a consent, please take notes and write down why you're doing it. Because it can come back and cause you a big problem. Right. Then the next step is privacy agreements. Now, privacy agreements is very important for your staff and for your third-party suppliers. Why is that? So somebody can take medical information from your practice and share it outside. Then you're going to be held accountable and liable for it. With a privacy agreement, you can hold that individual accountable for that information. And you need to restrict access only to those employees that signed the data security agreement. And again, also grant access only to the specific information needed for their role. We're going to get to that one a bit later on as well. And then minimize paper records. The advantage of digital is that you can see who access the information. What is advantage and disadvantage, and Shireen can talk about that one a bit more. Digital information do have an advantage. Physical documents, unfortunately, you see, here's the problem. If that file, if that file is lying here, you're not going to know, picked up that file and made copies or take pictures from it on a cell phone. You're not going to know it. And that's a risk of manual documents. So if you can, I would recommend try to move away or control these documents very carefully and lock them away. And then the next one, update your software. Stay updated, stay protected. You need to do updates because that fix vulnerabilities and fix security vulnerabilities and bugs, and enhance data protection and add new features. Ensure timely update of your system and workstations and all connected devices. And your IT advisor should at least install for you a firewall and antivirus and anti-malware software. Right. Then tip 5. Protect your practice and your patients by ensuring clear and informed consent. Ensure that you have a written, signed consent from each patient, explicitly allowing you to practice to process their personal information, health information, and share their personal health information. So you can get consent on 2 ways. One is a way of association, indirect access. Now, I remember at that time when POPIA came out, people went crazy. You were not allowed to take pictures at schools of children, and it was really this complete antic. And it was crazy for a while. And until I went to a church one day. Now, this church had a live recording And we're actually taking videos of the people in the congregation. I said, sure, no, well. And then they did it very cleverly. I'm sharing it this with you to think a bit out of the box. So what they said, when they started the service, I said, if you sit in this area, we will take video photographs, we'll take pictures of you. And by merely sitting in this area, you consent for us using your pictures and photographs, which will be shared on social media, etc., etc. And should you not wish to be in part of this, please put up your hand and go sit in the other area. So that is indirect allowance. Will that fly in a court to somebody? I won't know. I'm not the expert on that one. But for your practice, you need a written signed consent of explicitly allowing you to process information. There is no indirect kind of thing, please. Then the next one is lockdown. This is actually to PAIA's advice. Now, we touched a bit on this earlier. So only the health treating practitioners should have access to the patient's health record, reception account, and admin staff by access contact details, account information maker, and not should not have access to the patient's full patient file. And the next one. Now, do I need to say anything? Back up your data. Okay, so I don't know if anyone of you experienced a breakdown of a system. Out of not being backup, well, I worked in a company and we had riots in Lesotho, and they stole our file server, and we lost all our information. Yes, we had file backups in the bank. Now that time we didn't have online real-time backup, so we lost about 3 days, and that was a few million rands of damages. And yet today, a friend of mine, their business, their file server broke, and they lost all their data. And they had to restart and do everything over. So this one is imperative. I don't want to go on too long about that, but I'm sure you get the message. Right. We conduct regular audits. Here's the truth. Policies and procedures are only effective if properly applied. Yes, you can have all the big file out there with all the procedures, and I'll show you. I mean, we got some great stuff, but it needs to be applied in practice to be able to use. And then you need to regularly review and assess compliance with staff. You need to reinforce key policies to pursue consistent implementation. Yeah. So what is currently happening out there? I hope you understand the urgency of my message today. But since April 2024, last year, there have been 980 security breaches, compromise notifications, highlighting the weakness of data protection, issuing enforced notice to non-compliant organizations. Now, this is the ones we know about. This is scary, isn't it? This is big time. The problem actually lies that many people don't know they've been compromised. So the question is, do you know that you've been compromised or not? How can you make sure that you haven't been compromised? You really need to make sure that if you do get compromised, what do you need to do next? Again, we have some great policies for that. You need to do this, inform this party, inform a regulator, but don't get there. You first need to understand the particular system, and then only understand what you're going to do with a breach. So, here's the penalties for non-compliance. Fines up to 10 million for severe implications, violation, and imprisonment for up to 10 years in extreme cases. So the government made it quite clear you need to comply. I don't need to say more. But for me as a business person, the last one is actually more important. Reputational damages and a loss of patient trust. That's the bottom line. Because that can close your practice. So, listen to all of this. What would you reckon is the biggest risk? Okay, so unfortunately, I have to share this with you today. Unauthorized disclosure of patient information is your biggest risk. So in my world, in my life, I have received a couple of financial statements, which is not part of my business. So I don't know on your side, hopefully you guys are clever, you don't do it. But the risk on your side is just so much bigger than on my side. Because if a personal health information, remember level 2, special private information, lands up in the wrong hands, you can get in big trouble. And then the second biggest is your weak cyber security leading to data breaches. Now, where Shireen is going to talk for us next up, I would strongly recommend attend that session because, let's be honest again, I can do the policies, I can put the procedures, all the manual records, yes, I can do it. But it's highly unlikely someone's going to walk into your practice and put a gun to your head and say, give me this file. No, I think not. What is likely to happen is somebody from remote, anywhere in the world, will access your electronic files. That is your biggest risk, and that's what you need to protect for. So you need to be up to date and make sure you can handle it. And then improper handling and disposal of patient records. I think it goes without saying. If you dispose of a patient's records, shred it. Do not just throw it away. And then non-compliance with PAIA. Now, this one, biggest risk area, I'm not really convinced because you have information officer, and this is where information officer role comes in. This person needs to decide if they're going to give out information, yes or no. And if you do not, please make sure you know why you do it. Again, take your notes and take your time to do it. You've got enough time to do it. So then moving on. What is your critical actions to ensure compliance? So number one, you need to appoint an information officer. Is number one. And here I want to touch on the thing of visible compliance. I don't know what is the status of your practice today or your business, but visible compliance for me is somebody sitting in a regulator office and he logs online and says, okay, have you registered for an information officer? No. Then you're likely to be not compliant and you will be audited. You'll be first on the list. Second thing is, I'll check on your website. If you have a website, there's certain things you need to have, like a privacy policy, etc., etc. And again, if you do not have it, you're likely to be not compliant at all. And then the next one is you develop and implement a comprehensive POPIA PAIA internal policy and publish it. And remember, we talked about the third-party providers on the privacy agreement. That is number 3. You need to have it. And then number 4, which I would actually say is number 2, but is debatable. Then obtains the explicit consent for processing and sharing personal information as required. And then lastly, then conduct training session. So yeah. So this is what the typical POPIA PAIA policy framework looks like. It's a policies and procedure. Now, this can help the organization to do better. It isn't necessarily, you do not need all of it. So simply put, if you do not have a website, this is out. That part is just the documents is in there. But here's some good information in here. So typically your forms to get the access from your patient and also how to, if I want to cancel that access, and how to do that. So right, then in summary, POPIA protects your personal information and PAIA governs information access. Compliance is essential for patient trust and legal protection. Implement practical steps to safeguard patient information. And my final recommendation, regularly review and update policies, encrypt digital patient data, limit access to personal information, and conduct routine audits and assessments. And there you go. So I need to push that on. So this is a final recommendation. Conduct audits and risk assessment. And right, so thank you very much. That's all. Any question?
Any questions from anybody? Nobody? I'm sure you've got a question. Nobody wants a question. Oh no, you've got a question.
A case where you would like to just offload, let's say, with other colleagues about a patient, but you are not saying their name, just saying, this patient is overwhelming or this issue and so forth we wanted to talk about. So are we allowed to do that? Because I realize that it says we shouldn't give information or talk about the patient's, problems and their conditions and so forth.
Did you get that, Joubert?
Sorry, Joe, I didn't quite get that.
Sorry.
So I wanted to find out, in a case where you want to offload with other colleagues about a patient's condition, but you are not going to tell the name. It's just to say, okay, I've got this patient who's got this issue, and I don't know how to, come about giving solutions and helping them with intervention.
Okay.
So is that also breaching their, confidentiality?
Yeah. I think one should be just careful, and I'll talk to you afterwards if you do not mind, that you can get the exact circumstances around that in order to give you the best advice on that.
Anybody else? Okay. Joubert, thank you so much for that talk.